welcome back. I hope you're done with the part A, people. Yeah. According to your syllabus, there is nothing like part A and part B and all, people. Just for your understanding, so that whenever you're reading, you will have that sense of satisfaction. Sir, 20 papers done. Now, when you come to this page, mentally, you will feel that psychological difference will be there. So this is only now say 11 pages. You will feel that difference. So just for that sake, I've just done that, people. And second thing is, whenever you want to refer that, you will have a fixed page number to which you need to go to. That is the reason. Okay. So we will chapter 3 part B, Insolvency and Bankruptcy Code 2016. Yes, people. Now people listen carefully. When people in pandemic, yes, people, that too when the recent amendment, this entire chapter has been put like this. Not even one line was there. Entire 10 pages is an addition only. It's an amendment. Sir, just 1 year old amendment, people. It has come in April 2021. Yes, people. Sir, now what is this? Let us try to first understand the intention and then let us get into the chapter. People, when during this pandemic, COVID and all, people, corporate debtors, all of this was happening. That is a simultaneous story. But there was one sector, people, which was very greatly affected. That too in a country like India, people, which contributes the maximum. I'll not say maximum, but it also contributes to the predominant economical inflow of money for the country, people. It is done by a sector called as MSME. What do you mean by MSME, people? Micro, small, medium enterprises. Your MSME companies, MSME sectors. People, what used to happen for them? First thing, if at all they go under CIRP process, their claims are never so high. Sir, here you said 1 crore rupees minimum claim. Now, where should they go? Second one, people, theirs and all is pity. It's a little small. They cannot wait for 330 days. Now, Videocon, more than 2 years. Yes, I told you, technically it is not happening in India as on today's date. Because we try until the last moment. If it is not happening, what to do? Yes, people, now what is happening with regards to this MSMEs, people? We cannot wait for that 1 year and all. So people, law came up with one addition, amendment, people, a complete CIRP process for a MSME people. People completely, it is not for any other person, people. It is only and only exclusive for MSME sectors. Is this clear, all of you? Okay. Sir, now what is this called as? Is it something different, people? Almost, people, it will be same. CIRP will be is equal to PPIRP. Yes, people. Okay, sir, it is almost same. But people, yes, see, what is same, people? The methodology is same. So people, the methodology is same. That is, sir, adjudicating authority, committee of creditors. People, this terminology will come here also. But how it is done, a certain timeline difference. Sir, who will be the person who will take care of this entire process? So people, in those places, there will be some differences. I'll tell you. Yeah, to make your life better, I have made one more chart also for that. We'll see what it is. Yeah, people. Now, okay, sir, we are getting a fair tad bit of idea. Okay. Now, people, so whenever there is a corporate debtor, listen to this very carefully. Whenever there is a corporate debtor, people, corporate debtor, if at all he is not able to come out of something called as a debt trap, sir, that is when he will come to the authorities asking for help. And people, the amendment is only called as prepackaged insolvency resolution process. Prepackaged insolvency resolution process. Sir, in short, going forward, I'll be calling it as PPIRP. Sir, now first of all, people, let us try to understand why is it called PPIRP. First thing, people, in CIRP, what used to happen? Sir, you will initiate a application to file with NCLT. That is, you want to start your CIRP process. Okay. After that, people, IRP will be appointed, interim resolution professional. After he is appointed, people, he will start taking decisions, correct? He will start forming a committee of creditors, asking for claims. Everything is done after everything is initiated, correct? First process will start, CIRP commencement date will happen, and then people, everything else will start, correct? Here people, certain things, the basic platform will happen even before initiating the PPIRP. So sir, imagine people, a corporate debtor goes and files an application with adjudicating authority. People, even before filing an application with adjudicating authority, people, the corporate debtor, he does his homework even before going there. That is the reason people, we find the word called as prepackaged people. Prepackaged means people going there before that only it will start. That is the reason it is called as PPRP. Sir, wonderful concept, no sir. Wow, sir. Kuch wonderful nahi. All copy paste only. Such law is not new in the world, people. There exists this laws in many other countries also. Not say it is copy paste, but yes, we are not the first ones to introduce this. Yes, I can put it that way. Okay. Now let us try to understand how what. So people, there is only one section. Wow, sir, one section. That one section people has from 54A to 54T. Every alphabet is important. 54A, B, C, D, E. We'll go to T. Is this clear? All of you are getting a fair idea? Awesome. Now people, so let us start this, what it is, how it happens, everything. I'll tell wherever there's a difference, I'll tell you. At end, let us again summarize everything. Okay, now let us start. Sir, pre-packaged insolvency resolution process under 15A. Sir, corporate debtors who are eligible for pre-packaged insolvency resolution process. Sir, now our doubt is who can come under this PPIRP, sir? First one, listen carefully. CIRP, who and all can start? Sir, CD, OC, FC. Sir, PPIRP, who and all can start? Sir, what, sir? CD, OC, FC. No. People, PPIRP can be started only and only by only one person, people. Only one person can start it. Who is that? People, only and only corporate debtor can start PPIRP. FC, OC, no C. Is this clear, people? They cannot start. Only CD has the power. That is the reason they have given corporate debtors eligible for pre-packaged insolvency resolution process. We'll go. When we go deeper, you'll get fair idea. Now, sir, how will I start, sir? So, people, a corporate debtor classified as a micro, small, or medium enterprise. Sir, micro, small, medium enterprise under subsection 1 of section 7 of MSME Development Act 2006. So sir, this PPIRP option is available only to those MSMEs people, MSMEs. Okay sir, now our doubt is who is a MSME? People, that is also recently amended, people, 2 years back. Now this is what is the MSME, people. Sir, should we remember this? This is not there in your syllabus. That is the reason I have put it as Gyan. Correct, people, so that you guys will know. You need not rattamar this provision and all. But if they ask you, you should know. Sir, classification, sir. Okay. First one, people. Sir, what do you mean by micro? So, people, whether you are a micro, small or medium enterprise, it depends upon the manufacturing enterprises, people, majorly. Their annual turnover and their investment, people. These are the two criteria to decide whether a particular enterprise is a micro, medium or a small enterprise, people. The base factor how we decide what is the investment the enterprise has done and what is its annual turnover. So people, if at all our enterprise's investment in plant and machinery or equipment is not more than 1 crore and both conditions, people, investment not more than 1 crore, annual turnover not more than 5 crore. People, investment in plant and machinery, investment not more than 10 crore, annual turnover not more than 50 crore. Sir, medium people, investment not more than 50 crore, turnover not more than 250 crore. So, sir, accordingly, these people will be considered as MSME. Now, people are enterprise, which is a company or a LLP people. If it is an enterprise, sir, if it is a MSME, then they will come under your PPIRP process. Is this clear, people? Got a fair idea? Okay, sir. Sir, now we got a fair idea who can start it. Now, people, let us see the eligibility. Sir, how to start? We saw who to start. MSME? Yes, sir, correct. Now, who can start it, people? As I always told people, I told you all that time only, people. People, only a corporate debtor can file a PPIRP. People, OC and FC and all, they cannot start PPIRP. It is like a debt trap. I am only stuck. Please pull me out, says MSME sectors. Is this clear? Okay, sir. Sir, we have one doubt before we start even eligibility. What is that doubt? Sir, we want to know. Shall we do it now? Okay. I'll tell you one thing. Okay, when we'll do it. We'll do it with this only. I'll tell you. Okay, sir, eligibility. Now, corporate debtor will start PPIRP. Sir, now how? People, what did I tell you? This process is a PPIRP, correct? So, sir, pre-packaged. Meaning what, sir? Before I file an application with adjudicating authority, all that will be same. NCLT you will file, he will accept or reject everything. See, I have put a chart for that also. Everything, don't worry. Same, similar chart. Clear? We'll come back. Okay. Now, sir, pre-packaged, that is before application, there is some job you need to do. Sir, now what is that job? See, people here. A corporate debtor, first he should be a MSME. Okay, he's a MSME, sir. We got to know. Sir, in a CIRP process, the minimum amount of default we should have done is 1 crore. No, sir. Is there any criteria like that, sir? Here, people here, minimum amount of default should be 10 lakh. Minimum amount of default should be 10 lakh. Yes, people, below that MSME not possible. Okay. And people, certain other conditions should be satisfied. What are these additional conditions? First one, people. The PPIRP should have not, that is whichever is this MSME we are talking about, who is filing an application, they should have not undergone PPIRP or CIRP during 3 years preceding the initiation date. So people, whenever you are going to file the application, 3 years before that, you should have not already started PPIRP, you should have already not started CIRP. Is this clear? Okay. Second one, people, you should have not been undergoing CIRP. So, sir, when you're filing an application here, your CIRP should not be pending. It should not be ongoing. Yes, people. Sir, what is the difference? This is past. This is people present. Yes, sir. Third one, sir, liquidation order should not be passed. Yes, people, liquidation order should have not been passed. Then only you can come here. 3. Fourth one, people, it is eligible to submit resolution plan under section 29A. It should be eligible to submit resolution plan under section 29A. People, what do you mean by that? What is section 29A? What is section 29A? Try to think. Eligibility of professional. Hey, applicant, resolution applicant. Who cannot be, saw no. Undischarged, insolvent, all that part. So people, I told you here he only submits the plan. I mean, here he only initiates. What if he is a related party? I mean, I getting the point, people. You should not be disqualified, basically. Sir, fifth one, financial creditors representing 66% voting, which is not related parties, should have proposed insolvency professional to be appointed as a resolution professional. Concentrate. Now concentrate. Sir, first of all, sir, a corporate debtor who is a MSME, he can initiate PPRP. Minimum default is 10 lakh. Additional conditions, people, past PPIRP or CIRP in the preceding 3 years should have not happened. You should have not been undergoing CIRP. Liquidation order should have not been passed. It is eligible under section 29A. people, financial creditors representing 66% voting have proposed insolvency professional to be appointed as a resolution professional. Sir, we did not understand. People, now concentrate. Sir, in CIRP, what used to happen, people? In CIRP, what used to happen, people? Sir, financial creditors or your corporate debtor or your operational creditors, they used to propose a name. Yes, sir, they used to propose a name, that is insolvency professional. Sir, once the adjudicating authority passes the order, this insolvency professional will first become interim resolution professional. Okay. Sir, and after that, sir, in the first meeting of committee of creditors, they will make sure that if at all they want that person, or if they want, they can change also. Let us assume they will make him only a resolution professional. Sir, this is what is the order, sir. In CIRP, people in PPRP, the law says first you need to satisfy certain conditions before you're filing an application. What are that? We'll see. Even there are some more. Sir, now in this, people, first thing always remember, in CIRP, first difference, I'll be telling you then and there only. There is difference, try to relate. In CIRP, people, the approvals can be taken. In certain places it is 51%, 33%, people 66%, in certain cases 90%. Yes, people, so there is various percentages. People in PPIRP, throughout the lesson there is only one percentage, that is 66%. Whenever you need to pass any resolution, people, any voting, then it has to be by 66% majority. Okay, sir. Sir, now what is happening? People in the company, whoever are our creditors, people, they need to nominate one insolvency professional, that is you and me, to become what? IRP day. Here, people, there is no concept of interim resolution professional. You will directly be appointed as a resolution professional, people. Whoever is our insolvency professional, he will directly be appointed as a resolution professional. Is this clear, all of you? Yes, people. So this person will be a final resolution professional. There is no interim concept at all here. Why? Because everything is happened pre-packed. No. First only everything is happening. I hope you're getting the difference. Okay. So that is what we wrote here now. Financial creditors representing 66% voting have proposed the insolvency professional to be appointed as a resolution professional. Clear? Okay. So, sir, we need to satisfy all these conditions. Fair enough. And, sir, people, second condition, you have to follow all this. You have to fulfill all this. What is that? People, important, very important. Recent amendment. Declaration by majority of directors or partners. Sir, imagine if a company is going for PPIRP or partners are going, that is LLP is going for PPIRP, people, the law says the declaration has to be given by, if it's in the company, the directors. If it's the case of LLP, the partners has to give one declaration. What is a declaration? That CD shall file an PPIRP application within 90 days. Today you are taking all the approvals. Remember this 90 days. Down the line you will get one more 90 days also. That time this is not one and the same. Down there is one more 90 days. That time this is not one and the same. What are we saying here? People, imagine this day you are filing an application on this day. Imagine there is one day here. If you are planning to file an application with NCLT on this day, the law says, what does the law say, people? Before filing an application, you need to take care of some pre-packaged activities. So the law says, people, you have started that here. So whenever you started that pre-packaged activities, you need to make sure you will file an application with NCLT within 90 days. Now you are taking declarations, all that you are doing, no. Take it and you need to file it within 90 days to NCLT. That is the meaning here. Even later point of time, this 90 days will again come. Yeah, don't get confused. That is different, this is different. Okay, sir, the CD, corporate debtor, is telling that we will file for an application for PPIRP within 90 days. Okay. It is not to be defraud. Sir, it is not to defraud. What? People, why are you going for PPIRP process? Sir, I want to come out of this trap. My intention is not to defraud any creditors, not to defraud any person. Yes, people, so the intention should not be to do fraud. Third one, people, name of proposed insolvency professional to become resolution professional who is also approved. Yes, people, name of proposed IP to become RP. That is what, sir? Sir, that is suggested by your committee of creditors. So the directors and partners should also agree with such person. Whoever is the IP, sir, who will become the RP. In our application to NCLT, we will include all that. Sir, fourth one, people, there should be a special resolution passed. If it is a LLP, people, you need to pass 3/4 of the partner's approval for initiating PPRP. So, are you getting the point, people? Even before going to PPIRP, you are doing many things before that only. We will see still what and all you are doing. But is this clear, all of you? Okay, sir. Okay, now people listen carefully. Now, what and all we saw? People remember like this. Before you want to start your PPIRP, you need to satisfy certain conditions. One, MSME, second one, 10 lakh default, third one, already not started, previous 3 years, not undergoing CIRP, so resolution applicant, you are eligible under section 29A, liquidation order not passed. Now people, you need three people's approval. First one, people, directors, partners. How? Majority. Majority. They are not telling that 66, 55 and all. So the directors or partners will approve by majority. Okay, first approval. Second approval, you are taking from your shareholders or your partners. Yes, people, special resolution. People, the third approval. So total you are taking 3 approvals. People, approval number 1, declaration by directors and partners. Approval number 2, your shareholders and partners are agreeing. Approval number 3, people, prior approval of financial creditors holding 66% in value for starting PPIRP process. So people, approval number 3. Sir, quickly revise. People, 3 people has to give approval. One is declaration by directors or partners. Second one is your approval, special resolution by members or partners. Third one, people, financial creditors. Before going there only, you have to agree that we are okay with this PPIRP, starting PPIRP, and people, 66% voting share, we have to agree to it. Is that clear, all of you? Yes, people. And sir, you are telling that you have to take your committee of creditors approval. Yes, sir. I mean, people. So, sir, you are telling that we have to take their approval. Yes, people. Before they have to give their approval, you have to give them some information, right? So, people, they shall be provided with the declaration given by directors or partners, special resolution passed by members or your partners, people, and the creditors should be given base resolution plan. Sir, the creditors has to be given a base resolution plan. People, important difference. People, listen to this carefully. Sir, in PPIRP process, people, whoever is a corporate debtor, people, this corporate debtor himself will submit the resolution plan. He will only submit. The resolution plan is submitted by the corporate debtor himself. Sir, their resolution applicants and all used to come. Are you getting the point? Are you getting this point, people? All of you? Okay, sir. So, PPIRP, sir, the law says a corporate debtor only has to give the resolution plan. That is the reason, people, we call this resolution as base resolution plan. Important, this plays a very crucial role in this particular chapter. Sir, till now, whatever we have seen, sir, CIRP may, sir, your resolution applicants used to give a resolution plan. That is a plan to revive. Sir, what is the alternative? Instead of doing this, do this. So people will give us alternatives. So, sir, till now that was being given by our resolution applicant. Now, people, it is being given by corporate debtor himself. Sir, and this resolution has to be given, people. Resolution plan has to be given to the committee of creditors before their approval is taken. I hope this is clear. All of you? Yes, sir. Okay. Now, sir, so we have taken everything, whatever is possible. Hey, people. So, sir, 54A, whatever we saw. See, before going to the tribunal only, your half the job is done. You have taken everyone's approval. You have submitted to the committee of creditors base resolution plan. I have still not told that this has been approved. Yes, people. Okay, sir, we have provided all this. Okay. Now, people, we are filing an application to initiate PPIRP. Sir, 54C. 54A people eligibility and your pre-packaged whatever you need to do. Now people, we are filing an application to the adjudicating authority. Same people, NCLT only. Sir, now how? See here people. The corporate debtor or the corporate applicant. Corporate debtor or people corporate applicant. Yes, people. Sir, so who can start, who can initiate the corporate, what is this, PPIRP process, sir? It can be initiated by the corporate debtor himself or people, we have written the word called corporate applicant. Sir, this corporate applicant definition was also there in your first part. Sir, CIRP it was there. So let us know who is this corporate applicant. So people, in the definition, corporate applicant means people, a corporate debtor, that is the MSME or the CIRP, whoever is going there, that is the company himself. So corporate debtor people. Second one, member or partner of the corporate debtor who is authorized to make an application for CIRP or PPIRP process. So sir, first one is your corporate debtor people. First one is corporate debtor. He himself can file a application. Sir, second one, sir, the law says the member or people, the partner, member or partner of whom, sir, of corporate debtor. Okay, sir. Third one, people, an individual who is in charge of managing the operation and resource of corporate debtor. So basically, people, a person in charge. Person in charge of corporate debtor people. So this person will file an application. So whenever I say corporate applicant, they are all the people in the corporate debtor only. They are not outsiders. Everyone are within the company only. So they can file is what they are saying. Fourth one, people, a person who has the control and supervision of financial affairs of the corporate debtor. A person who has the control and supervision of the financial affairs. So people, something like, say for example, CFO, Chief Financial Officer. Can I say that? A person under whose control and supervision the financial affairs of the corporate debtor is. Can I say CFO? So people, these four people are covered under the corporate applicant. Yes, people. So these people can start PPIRP process. Who? Corporate debtor or any of these people. Corporate debtor, member or partner of corporate debtor, person in charge of corporate debtor, and people, basically CFO, control and supervision of financial affairs. This is clear? Hey, all of you, not at least. Yes, sir. Okay. Sir, okay, got a fair idea. Now, sir, let us go back. Sir, corporate applicant, okay. Sir, and he satisfies 54A. What is 54A? This one. Sir, 10 lakh MSME, sir, additional conditions, sir, declaration, special resolution, and your financial creditors approval. They should have nominated a person who is IP to become a RP. Yes, people, when will he become? When adjudicating authority appoints. We'll see that. Is this clear, all of you? He has satisfied 54A, sir. Okay, now, people, they will file an application for initiating PPIRP process with whom? Same person, adjudicating authority. Who will be our adjudicating authority? Same, NCLT only, no new person and all. Okay. People, along with that, they have to give certain documents. What are those two documents? People, declaration, special resolution, FC approval. 3 approvals. Okay. Second one, people, the proposed resolution professional. Basically, our insolvency professional. Sir, once you pass the order, this person will become resolution professional. So that person's name. Third one, people, we will file a declaration on existence of any avoidance transaction. What is this avoidance transaction, sir? In my company, if at all, that's preferential, sir, fraudulent transactions. Yes, people, that is, will come, people, next chapter, that is part C, will do that. No, part D will do that. Yes, people, declaration on existence of any avoidance transaction that I have to declare, sir, such transactions had happened, preferential, fraudulent, exorbitant. Yes, people, all that. Sir, next one, sir, books of accounts, people. Basically, I need to inform about my financial status. So my books of accounts. So people, all these things have to file along with my PPRP application. Try to recollect. 54A. Yes, sir. Sir, the corporate debtor alone can file a PPRP application. Okay, sir. Along with that, I'm filing some documents. Sir, declaration, approvals, shareholders as well as committee of creditors. Sir, proposed resolution professional. Sir, declaration on existence of any avoidance transaction. Sir, and books of accounts. Yes, sir. Okay. Now, sir, adjudicating authority has 14 days time. Sir, same thing. Yes, sir. Sir, adjudicating authority may reject or admit. Sir, same thing. Same thing. Sir, if at all adjudicating authority wants to reject, he needs to give you an opportunity to rectify your application, people, 7 days. Clear? Hey, going inside. Same. Okay. Sir, if at all he admits the application, then what will happen? People's PPIRP shall commence from the date of such admission. Clear? Same thing, noda. China, correct or no? So, sir, after he admits the application, people, he will pass an order. Yes, people, the order is passed under section 54E. Sir, where are the middle sections, sir? People first understand the process. Yeah, again, I'll take you some important notes. I'll make you guys see everything. We'll see in detail only. But understand the process. Sir, order, people, will be passed under section 54E. What is the order? People, same da. Moratorium will start from the date of admission of application. That is, I'm passing the order. People, it will end on when the PPRP ends. Sir, you did not tell us how many days this PPRP should end. I'll tell you, wait. Sir, no, sir, tell sir, we can't wait, sir. No, sir, anxiety, sir. Okay, people, 120 days will be given. Clear? Sir, okay, extension. No extension and all. Only one time, 120, that's all. Sir, if it is not possible, then get out of the motherland. There is nothing. The PPRP only comes to an end. Correct, people? Okay. Okay. Sir, how, sir? That they are telling 180. This they will tell 120. Next chapter, people. I mean, your part C. There you will see 90 also. Fast track insolvency resolution process. But that is very easy, people. It is nothing, people. But just, yes, for you to know that there is one more process, I have just maintained it as a part 3. We'll see. Okay. Sir, same thing, people. There also we appoint from the date of the order, people, moratorium period will start. People, now whoever is our insolvency professional, he has become our resolution professional here. Isn't it a difference? There, our insolvency professional will first become interim resolution professional. Here he is directly becoming a resolution professional. Pay attention. Sir, third one, sir, he can cause. He will tell the resolution professional to give public announcement. Correct, people? Okay. Sir, within 2 days of the commencement, sir, order has been passed. Yes, sir. Sir, PPIRP process has started. 2 days has happened, sir. The date of the order excluded. So next day, 2 days has done. Monday order got, Tuesday, Wednesday. Today is Wednesday. The law says, people, corporate debtor shall submit to resolution professional. People, corporate debtor. People, you need to save time here. Everything you have done in PP only. Pre-packaged, everything is ready. The moment RP is appointed, people, you will give all the files to him. Properly, everything properly kept. So people, the corporate debtor shall submit to the resolution professional, our final person. What and all we'll give, people? We will give him preliminary information memorandum. Hey people, difference number 2. Sir, what, sir? Hey, in CIRP, who prepares information memorandum? Resolution professional prepares. People, here we want to save time. No, in pre-package we have saved time, people. The company itself, the CD corporate itself has already prepared and kept information memorandum, financial summary. हमारा assets कितना, हमारा liabilities ಎಷ್ಟು, हमारा balance sheet ಎಂತ. Yeah, people, everything he has kept ready. Okay, sir. For resolution plan, resolution plan. You are telling base resolution plan, corporate debtor only will submit. No, sir. Now why are they submitting information memorandum for resolution plan? This, keep it aside for some time. I'll connect to you. Okay. So, sir, I will give preliminary information memorandum, and people, I will give him list of claims. People, everything is ready, da. Claims are also ready. People, I will straight away just pass on the list of claims people, the creditors, who are my financial creditors, who are my operational creditors, with along with their amount outstanding, everything I've kept it ready. I will just pass it on. Okay, sir. Now हमको एक doubt है. Sir, नमको doubt दे. Sir, माको doubt उन्दे. हाँ, सुन रहे हैं. People, list of claims. Okay, who gives? Sir, company is giving the list of claims to resolution professional. Got it. What if I have missed out any person's name in that list of claims? The law says if at all there are any omissions in the list of claims we are giving, we have excluded a creditor's name, then people, the promoter or the director or the partner of the corporate debtor, or sir, not these people, any other person who has authorized the list of claims, sir, they shall be liable to pay compensation for such loss suffered by the creditor. Sir, first thing, sir, the corporate debtor is giving a what? Sir, list of claims to the resolution professional. Sir, in that list of claims, if at all I miss any person's name, sir, my promoter, my director, my partner, or the person authorized people, they will be liable for the people who have suffered the loss. Clear? Okay, first understand that everything is same only. Okay, sir. Now, within the same 2 days, there is one more alarm. ये क्या है? The corporate debtor shall also submit. The corporate debtor shall also submit the base resolution plan. The corporate debtor shall also submit a base resolution plan to the resolution professional. So people, we are ready with everything, Noda. Resolution profession, we have our resolution plan. You don't have job here. Everything we have only done. PPA, prepackaged process. So I've kept ready everything. Why? We need to save time, no? So sir, 2 days of the initiation of PPIRP, the corporate debtor will give one more file. Sir, what is this? This is base resolution plan. A resolution professional, we think we can do like this. We are just giving our concern. We can do it this way. Yes, people. Okay. Now, what will the resolution professional do? Listen carefully. Sir, the resolution professional has got now 3 things: list of claims, information memorandum, and sir, your base resolution plan. Now, people, within 7 days of commencement of PPIRP, he shall form the committee of creditors. It will again be people, financial creditors. If at all it is not there, sir, it will be as specified by central government. It is not yet specified. Generally, people, all this know. Everything will be in rules, people. For you guys, the rules are not there. That is the reason your weightage is little less. Yes, sir, less. Amma, sir, we are done, sir. Listen, we are almost done. Yes, people. So, sir, the corporate, the resolution professional, RP, what will he do, sir? Sir, we have given him all these 3 documents. Okay, now people, the committee of creditors shall be formed within 7 days of the commencement of PPIRP. Okay. And sir, the first meeting of the committee of creditors should be held within 7 days of the constitution of the committee of creditors. Technically, people, we have 14 days, correct? 7 days to come in, 7 days to constitute, 7 days to to conduct the meeting. Correct, people? Okay. Sir, now whatever is the base resolution plan we have given to the resolution professional, sir, now the committee of creditor is formed. People, here we just showed it to financial creditors. Here base resolution plan, we have just shown it to the financial creditors, correct? Sir, now the committee of creditors, entire people are there. The committee is there. Sir, now the same resolution plan shall be, the resolution professional shall present that base resolution plan given by the corporate debtor to the committee of creditors. Hey, you financial creditors. Hey, you committee of creditors. Your corporate debtor, he himself has come up with a plan. This is the plan. What do you guys think? So people, now see here, The committee of creditors, according to section 54K, people, that is very important. Yes, people. So there they will approve or reject the plan. What will happen there, we'll see. That is very, very important. 54K. So in 54K, people, they will either approve or they will reject. If they approve, people, the approved plan shall be submitted to the adjudicating authority. The approved plan shall be submitted to the adjudicating authority. Yes, people, sir, what if it is rejected? People, if it is rejected, people, PPIRP comes to an end. The NCLT may pass a liquidation order also if it deems fit. Okay, sir. Sir, we have filed our approval. Whatever committee of creditors has given, we have filed that, sir. Now, people, adjudicating authority has 30 days time. You have filed it, sir. Adjudicating authority has 30 days time. Remember carefully, people, in this process, they have divided the timeline to two things. One is 90 days, one more is 30 days. Together, people, it is called 120 days. So, sir, PPIRP process has to be completed within 120 days. There is no extension. Is this clear? Okay, sir, we understood, sir. So, people, adjudicating authority will have 30 days to either approve or reject the plan. People, that is this 30 days. Okay, sir. Sir, now what is this 90 days? People, this 90 days is from the date of initiation of PPIRP and the day you submit your approved plan to the adjudicating authority. I repeat, from the day your PPIRP started, commenced, to the day you submit your approved plan, whichever is approved by committee of creditors, the approved plan you submit it to adjudicating authority. This day, you are submitting it here, no. The law says, people, you need to submit it within 90 days. So within 90 days you submit, within 30 days he will approve or reject. This is how it is categorized. Is this clear? Okay. Now adjudicating authority, people, he may either reject or he may either accept it. So if it is accepted, people, we saw Videocon case. People, same thing. If you guys want, people, you can appeal against such order. So if it is rejected, people, it may lead to liquidation. Sir, now we will come to the time process, people. Important, sir, note. Sir, what note, people? The timelines under this particular chapter, which is given in section 54D, says the resolution professional to file, the resolution plan, resolution professional to file, the resolution plan approved by committee of creditors within 90 days from commencement of this particular PPIRP. Can I say that is this line? Yes. Okay. Sir, adjudicating authority to decide within 30 days of receipt of the plan. Can I say this? So, sir, 90 plus 30, sir, the law says PPIRP to be completed within 120 days. There is no extension. क्या है? ಏನು ಡ್ರಾ ಆಗ್ತಿದೆ? Something went inside. This is PPIRP process, people. Yes, getting a fair idea. We'll go. There are some more details also. There is one some two sections which is very important. I'll take you that in detail only. But we have covered majority part. 54A, this is majority. This is very important. 54A. And people, 54C will come into picture. Yes, sir. And people, 54D, which talks about timeline. Sir, then people, 54E. Sir, then people, 54G. Then people, we have seen 54I. 54K, we will be completely looking at another place. And people, 54L and M. Yes, people, got a fair idea how PPIRP is happening. So, sir, first thing, sir, it can be only initiated by corporate debtor, MSME. There are some pre-criteria, declaration and committee of, financial creditors approval 66%, special resolution to be passed. Sir, once a resolution professional is appointed, within 2 days, people, we will give an information memorandum, list of claims and base resolution plan. Everything is ready. Sir, he will submit it to committee of creditors. If committee of creditors agree, people, the same base resolution plan will be submitted to adjudicating authority. Clear? But there is a chance for other plans also coming into picture. What is that? Only we'll see. That is only 54K. 54K is very important. We'll see it in detail. Okay, sir, we got a fair idea. Fair enough. Now let us start The next part. Sir, people listen to this very carefully, da. Sir, one more difference, sir. See, there only I'm telling you simultaneously where are the differences. One more difference. What is this? Sir, management of affairs of corporate debtor during PPIRP. People go back, flashback. The moment IRP is appointed, people, what is his first job? He will take over the management of the affairs of the LLP or the company. People, look here, there is two scenarios. One is people 54H. Other one people 54J. Sir, what does 54H focus on? People generally, management of affair people, generally, in general instances, even though the resolution professional is appointed people, it will make no difference. Whoever are our directors or partners, they will only continue the management of the corporate debtor. Resolution professional will not take it over. And people, the promoters, members, or any other personnel, say for example KMP or any officers and partners, they shall exercise and discharge all their rights and obligations. So people, what do you mean? What do you mean to say here? People, the entire company will be like that only, intact. Resolution professional will not at all touch the management. They will all continue in the general scenario even after PPRP starts. So management of corporate affairs of the corporate duty during PPRP, we will not hand it over to resolution professional. However, if any fraud or mismanagement, sir, if at all there is any fraud or mismanagement that is given under section 54J, what does it say? Committee of creditors may, with 66% voting. So people, if committee of creditors, after, yes, we have not taken over the management, it is with directors only, okay. But people, those buggers have been doing fraud. They have been all doing fraud. Now what to do? Committee of creditors will call for a meeting. They will, with 66% voting, they will say, people, enough is enough. Take the management from the directors and give it to our resolution professional. So people, COC may with 66% voting decide to vest. Vest means people to give. Going for this person will have. Who has the power? The management of corporate debtor with resolution professional. So by default it is not done, but if at all people, if there is any fraud or mismanagement, we can change this. This is possible. Sir, for which a resolution professional shall apply to the adjudicating authority for approval. So he will also intimate your adjudicating authority. If AA is also of the opinion that yes, there is a presence of fraud or mismanagement, then he shall pass an order accordingly. Yes, people. So what does he say? He will say, yes, the A directors, you guys come down. Our person will take over. So that is given in 54J clause subsection 2. Is this clear, people? All of you, this part? Yes, people. So ideally, people, your directors or partners only will take care of the management of the affairs of corporate debtor. However, sir, if at all there is fraud or mismanagement, COC by 66% voting people can appoint the resolution professional to take care of the management of the company. Is this clear? Fair enough. People, open your brains, da. Hand will come a little shake. Is it da? No, sir. People, very easy, da. What is that? Now listen carefully. Listen carefully. What is this? People, now what is happening, da? Sir, PPIRP has started. Yes, sir. Sir, our corporate debtor, हमारा corporate debtor, Namma corporate debtor has submitted a base resolution plan to, sir, a resolution professional. Now what has he done? Sir, he has given it to committee of creditors. Now people, committee of creditors says act 2. Committee of creditors are saying act 2. What type of resolution plan is this? We are not going to accept this. अब क्या करने का ఈగేంలో ಮಾಡ್ತೀರಾ ఇప్పుడు ఏం రా చేస్తారు జీ what will you do? Are you getting the point? All of you, manzilayo people, are you getting the point? என்னடா உள்ள போச்சா இல்லையா Yes, people. Now, people, what will happen? Concentrate. The resolution professional, we had given him something called as information memorandum. Correct? Why is information memorandum used? Now, people using this information memorandum, he will now again, people, we will go back to CIRP process. What? He will call resolution applicants, people. The resolution applicants will submit one more resolution plan. Now, people, the committee of creditors will compare the resolution plan given by the resolution applicant and given by the corporate debtor. So these two resolution plans, one is BRP, base resolution plan, and RP, our usual resolution plan. These two things, people, they will be compared. Whichever is beneficial, people, that will be adopted and that will be passed on to the adjudicating authority. This is what happens in 54K. Is this clear? We'll go in detail, but I just wanted you guys to know how it happens. Now, people, consideration and approval of resolution plan 54K. Concentrate. Upon commencement of PPIRP, that is adjudicating authority has given you the order. Within 2 days, the corporate debtor submit base resolution plan to the resolution professional. Correct, people? Till now we have seen. Sir, who will submit this? Corporate debtor. Corporate debtor shall submit. Corporate debtor shall submit base resolution plan to the resolution professional. Correct, people? We have seen this. Now, what will he do? The base resolution plan which we have given to resolution professional shall be submitted to the COC. Correct, people? So, resolution professional will submit it to COC. Now, people, COC may provide corporate debtor an opportunity to revise the base plan. Now, people, the COC says, hey, I have not yet looked at it, or I have looked at it, I am just giving you one more opportunity. It is optional. COC may tell the corporate debtor to make any changes to the base plan. Whatever you have given me, BRP, base resolution plan, I can give the corporate debtor an opportunity to change that, make any changes in the base resolution plan. Okay, sir. Now imagine we have changed or we have given the same thing. Okay, now people, imagine the base resolution plan is not approved or it is approved by the COC. Let us first finish off the approved part. Sir, if at all the base resolution plan given by our corporate creditors, our committee of creditors, sir, the committee of creditors has approved our base resolution plan which is given by corporator with 66% voting. In this entire chapter, only 66% voting you will see. Sir, and it does not impair the claim of operational creditors. Impair means people to destruct or people damage. Sir, impair means people damage or destruct. So people, what is the law saying? Approval. Sir, committee of creditors have approved our base resolution plan with 66% voting and they also feel, yes, operational creditors ko hum. People, we are not making any nonsense. We are not making them lose any money. We are protecting their claim also. We are not damaging their claims. If everything is satisfied, people, the approved plan within 90 days of commencement. Within 90 days, this is what I told you. One more place, 90 days will again come. This 90, 90, 90, 90 nahi hai. Hey, Friday night, people, this 90, that 90 is different. Sir, what is this 90? I gave you a bifurcation of 120 days. No, that is this 90. The moment PPIRP starts and you need to submit a plan to adjudicating authority, this entire process you will have 90 days time. So within 90 days of commencement, people, you have to submit your approved resolution plan with adjudicating authority. Clear? Okay. Now let us look at, sir, what if my resolution plan is not approved? Sir, my resolution plan is sir, people, my resolution plan is not approved. Okay, sir, now what to do? People, my resolution plan is not approved by COC or it impairs any claims of operational creditors. It is damaging some claims of operational creditors. Impair means, people, generally in simple language, I'll tell you. Imagine if a person has to get 100 rupees. You're not giving him the complete 100, meaning he's taking a cut. There is a reduction, that is called impair. When you're not able to discharge in full is called impair. Got a fair idea? Okay. Now what is happening? See, sir, not approved by COC or it impairs any claims of OC. Sir, now what will happen? The resolution professional shall invite the resolution applicants to submit resolution plan. So people base resolution plan, committee of creditors have not agreed. Now what to do? So people, we are inviting the resolution applicants to the picture now to submit a resolution plan. Clear? So resolution professional shall present to the committee of creditors the resolution plan which conform to the requirement. Because depending upon the information memorandum, they would have said this is what is the requirement. So whichever is proper, the resolution professional will shortlist and he will present such resolution plan given by the resolution applicant to the committee of creditors. Now what will committee of creditors do? Committee of creditors shall compare between the base resolution plan which the corporate debtor himself has given and resolution plan by resolution applicant. Now sir, the law says if no plan is selected, the resolution professionals shall file an application for termination of PPIRP. Sir, now what is this 54K12? Sir, now we have finally come to this process. What? Sir, I have given lastly people one resolution plan and our base resolution plan. Now committee of creditors people, if they agree, it's okay. If they do not agree any resolution plan, our resolution professional will file an application with AA. Sir, I had enough, sir. Kindly terminate our PPRP process. So people, resolution professional, if no plan is submitted, he will write a letter people. He will file an application to the our adjudicating authority people and he will ask for termination of the PPRP. Is this clear? Okay, sir. Now people, committee of creditors, imagine if they have approved, committee of creditors shall approve the best with 66% voting. Same thing people. Provided if such plan impairs any claims owed by corporate debtor, the committee of creditor may require for dilution of promoter shareholding. Sir, now what is this? Listen carefully. Sir, now whatever is the plan which has been approved by committee of creditors. Sir, now whatever is the plan which has been approved by our committee of creditors. Sir, in that plan, sir, if we follow that plan, sir, then this plan impairs the debt of, sir, it impairs the debt of creditors. It can be OC or FC. Sir, what do you mean by that? Sir, we need to receive, sir, somewhere around, for example, people, we need to receive somewhere around 50 lakh rupees. Sir, but if we follow this particular resolution plan, sir, we will get only around 35 lakh rupees. So, sir, we are losing 15 lakh rupees. The law says people, wherever our debt is getting impaired, damaged, we are not able to get the full amount. The law says people, the corporate debtor. Sir, who is the shareholder? Sir, basically our promoters. The law says people, hey, you promoter, whatever is your shareholding in corporate debtor, how much do you hold? Asked adjudicating authority. I said, sir, I have 60%, sir. The law says, okay. Now they are reducing their claims, right? Then you do one thing, even your rights will be reduced. People, there will be dilution. His shareholding in the company will be reduced. Why should the external parties reduce their money? So people, the promoters holding, there will be dilution. That is what we saw here. Read, COC may require, it may require for, provided if such plan impairs any claims owed by corporate debtor, COC may require for dilution of promoter shareholding. Is this clear, all of you? Okay, sir. So people base resolution plan or the resolution plan given by resolution applicant. COC will select the best one. If not selected, resolution professional will file an application with adjudicating authority to terminate the PPIRP. Okay, sir. Now sir, COC has approved the plan. They may ask for even dilution. Okay. Now such approved plan will be submitted to adjudicating authority. Such approved plan shall be submitted to adjudicating authority. Adjudicating authority may either accept it or reject it. We just saw. He will do it within 30 days. People, for reject. Sir, reject means what is the ground, sir? People, the grounds are given in 54L. Sir, what is the ground, sir? People, if at all the plan cannot be implemented, what dumb plan does this? This cannot be implemented at all. Don't you have common sense? Says yeah. Or people, you have contravened 54J2. Sir, what is 54J2? We have written no. 54J2, what is that? Sir, in the company there was a fraud or mismanagement. So adjudicating COC has with 66% majority, they have said, sir, the management of the affairs has to be given to the resolution professional. Sir, the adjudicating authority also passed that order, but people, the corporator did not comply this. They have not appointed that resolution professional. They have not given the affairs to him. So people, contravene 54J2 or plan cannot be implemented. So people, in such cases, it can reject the plan, terminate the PPRP, it may pass liquidation order. Whatever is the PPRP cost shall be included in the liquidation cost. Why? The next is liquidation. No. Sir, so what about the resolution professionals' expenses, information memorandums, or resolution applicants? So people, everything will be added to the cost of liquidation. This is clear, people. All of you got a fair idea. So people, we have almost done with this PPRP, people, but let us randomly run through so that there are some things which needs to be covered from here also. So sir, first one, sir, applicability, people. Not undergoing, eligible to submit resolution plan, liquidation is passed. Is people, a related party, sir, 66% approval, this we have seen. So the majority of the directors, people within 90 days, it is not to defraud any people, name of the insolvency professional, special resolution, approval from financial creditor 66%. Prior to seeking approval, you need to give some documents to financial creditors. 10 lakh limit. We have seen all this. Okay. 54B, duties of resolution professional before initiating prepackaged insolvency process. Okay. So sir, the duty of resolution professional before initiating PPRP. So sir, we have not yet filed application. The resolution professionals has certain duties itself. What is that? See here. The insolvency professional, we have not yet appointed him. That is the reason we are calling him as IP only. Proposed to be appointed as resolution professional shall have following duties. Sir, what are the duties, people? He shall prepare a report. What is this report? Corporator meets the requirement of 54A. All the approvals and all is taken. He shall file all those reports with the board. Sir, whenever I say board, people, it is always IBBI. So sir, before even filing our PPRP application, our insolvency professional will take our file. He will see whether 54A is satisfied. He will also intimate to IBBI. And he will perform such other duties. Duties and all is there, we'll see. Is people, now 54B, the duties of the insolvency professional under subsection 1, that is this, shall cease if the corporator fails to file an application for initiating PPRP within 90 days. We set a declaration, no, we will initiate the process within 90 days. If you do not file, the duties of insolvency professional will come to an end. Second one, the application for initiating PPRP process, if it is admitted or rejected by the adjudicating authority. Sir, ye kya hai, sir? Sir, the duties of insolvency professional shall cease. That is, it will come to an end. If application for insolvency, that is PPRP, sir, it is filed. If it is admitted or rejected, sir, if it is rejected, insolvency professional's duty will come to an end. Sir, if it is admitted, why will it come to an end? If it is admitted, why will it come to an end? People, as an insolvency professional, your duties will come to an end. After it is admitted, you become a resolution professional. No, new duties will start. The duties are there. Clear? Notable point. The fees payable to the insolvency professional shall form part of the PPRP cost if application is admitted. Yes, people, because it is application to initiate pre-packaged insolvency resolution process 54C, where a CD meets the requirement of section 54A, a corporate applicant thereof may file an application with adjudicating authority for initiating PPRP. Sir, along with that, people, I'll be giving declaration, special resolution and all that. We have seen this. Sir, I will give a declaration regarding existing of fraudulent, avoiding transactions, name and consent of who will be a resolution professional, books of accounts, adjudicating authority 14 days, admit, reject 7 days. Sir, PPRP shall commence from date of admission. Correct, people? Timeline, people. 120 days. Sir, shall submit the resolution plan to adjudicating authority within 90 days. Okay, that 30 days will be given down. We'll see that. It comes when the application is approved. Okay, so but technically, people, 90 days you need to submit the plan. 30 days, people, it is for them to submit the approval. Is this clear? I mean, adjudicating authority. Sir, declaration of moratorium and public announcement during pre-packaged process. Sir, 54E, we wrote no. Sir, moratorium will be same, people. We will appoint a resolution professional as named in the process who is not having any disciplinary proceedings pending against his name. That is same. Sir, or based on the recommendation made by the board, if any disciplinary proceeding is pending. Sir, if at all the person you have proposed, on his name there are some disciplinary proceedings pending, there is some cases going on, then IBBI will propose a new resolution professional. We will cause a public announcement, period of moratorium until PPRP ends. Duties and powers of resolution professional. People, it will be almost same as their only, nothing more will come. But just see. The resolution professional shall conduct the PPRP process. Duties, people, first one, he will confirm the list of claims submitted by corporate debtor. Correct? Ask. Corporator gives. People, he will inform creditors, maintain updated list of claims, monitor. Sir, what is this updated list of claims? What if, people, I have missed out giving some names and later they said that we are also creditors, I need to add them to the list. So that becomes updated list of claims. Monitor management of the affairs of the corporator, inform the committee of creditors in the event of breach of any of the obligation of board of directors or partners. That is when COC will appoint resolution professional as your management of affairs to take over the control. He will constitute the committee of creditors, prepare information memorandum on the basis of preliminary. People, prepare, read these words carefully. Prepare information memorandum. So resolution professional will prepare on the basis of preliminary information memorandum. So first a basic document is given by the corporate debtor, that is preliminary information memorandum. On that he will prepare one document, that is information memorandum. Why? To get the claims, resolution applicants. File applicants for avoidance or transaction, that fraudulent transactions will do. So the resolution professional shall exercise following powers. That was duties, this is power. He can access all the books of accounts or records, whether it is in electronic form or any other way with utilities, information utilities, wherever it is I can go and check. You can access the books of accounts, people. If it is available on any of the government authorities, auditors, I can go and check there. I have a right to attend the meetings, people. That is board meetings, committee meetings, all that. Appoint accountants, legal or other professionals. Collect all information relating to the assets, finance, operations and all those people of the corporator for determining the financial position of the corporator and existence of any transaction that may be within the scope of provisions relating to avoidance of transaction. What are those things? We'll see that, people. Take such other action as may be prescribed. From the date of appointment of resolution professional, financial institutions maintaining accounts shall furnish all information. If you guys remember, it is all cut, copy, paste. It was there in CIRP also. But yes, I'm just going through. The personnel of the corporator shall extend all their assistance. Officers and all should support the resolution professional. The fees of the resolution professional and any expenses incurred by him for conducting the PPIRP shall be determined in such manner as may be provided. The committee of creditors may impose limits and conditions on that fees and expenses, how much to be paid to him, and the people that fees and expenses for the period prior to the constitution may be ratified. These people, we saw the same thing, even committee of creditors can do that. IRPs, the fees and expenses shall be borne in such manner as may be specified. Okay, sir, list of claims, preliminary information memorandum. People, 54G, we have done this. What is that? Sir, the company will give list of claims and preliminary information memorandum. If any person suffers a loss, promoter, director, partner, and any person authorized, sir, they shall be liable to make sure their damages are repaid. Sir, no person shall be liable if the list of claims or the preliminary information memorandum was submitted by the corporator without his knowledge or consent. If he says that, sir, I did not know that his name was excluded and I did not have a proof also, if he can prove that, then people, he will not be liable. Any person who sustained any loss or damage as a consequence of omission or material information which has been mismanaged. Sir, my name is not included. Such person shall be entitled to move to a court having jurisdiction for seeking compensation. So people, whoever has suffered the loss, he can come and apply to the court for this compensation. Clear? Sir, management of affairs, people, I told you, it will continue. See people, during the PPRP, the management shall continue. Meaning people, they were doing, they will only do. Who? Our corporators, director, partner, promoters and all that people. Yes, the connected point is this 54J. Now whatever we have seen. See where the committee by vote of not less than 66%. It may apply to adjudicating authority. Adjudicating authority is also of the opinion that the affairs of the corporator is conducted in fraudulent manner or people there is mismanagement. Then it shall pass an order vesting the management of the corporator with resolution professional. So if at all it is satisfied, yes, this has happened. Sir, then it will pass an order, 54 people, whatever we saw. Sir, 54J2, yes, people. Now people, the moment we appoint the resolution professional to take care the duties of our managing the control of the affairs of the company people, sir, what and all he can do. So people, this I have given you what is that section. It is not there in your book, I have just added. Yeah, so that you will know what is that section. You need not turn your pages. Now they are saying all those sections shall mutatis mutandis apply. Mutatis mutandis means people same to same. Whatever was there in CIRP will apply here also. What does that see here? Sir, once the corporate debtor, sir, his management now is taken over by the resolution professional. Now it is no longer with directors or partners. Sir, subsection 2, 2A of 14, meaning people, essential goods, licenses should not be terminated. That will apply. Section 17, management of affairs of corporator by interim resolution professional. People, his duties, IRP, whatever was there, it will come here now. People, clause, basically section 18, duties of IRP. Yes, people. Sir, section 19 and 20, 19 people, person to extend cooperation to IRP. Management of operations of CD as a going concern. Whatever the sales and all, we will continue that. Sir, duties of resolution professional. IRP became resolution professional. Sir, approval of committee of creditors for certain actions. People, what is that? There was a big list, no, for which you need 66% approval. That will also mutatis mutandis apply. Mutatis mutandis means people same to same. As it is, it will apply. Is this clear, all of you? Pakka? Okay. Now, sir, committee of creditors, people, 54I, within 7 days, constitute a committee of creditors shall be altered on the basis of the updated list of claims. So, sir, what if new names are added? We can add them to the committee of creditors. However, any alteration made, whatever is the past decisions, they will still be valid. It will not have any impact on the past decisions. First meeting within 7 days. Other provisions, mutatis mutandis. Yes, people, CIRP. Sir, what is other provision? Your notice of the meeting, all those things. Sir, consideration and approval of resolution plan, 54K. This I have already taken you through thoroughly, people. I have covered everything. So people, corporators will suppose he will submit a base resolution plan. Opportunity to revise the base resolution plan. Committee of creditors may approve the base resolution plan. If not, people, if they do not approve or if there is any impairment, so we will take the fresh plan and people, they will compete with the base resolution plan. So resolution plan, base resolution plan. So whatever is agreed, people shall present to the committee of creditors. Now they will evaluate the resolution plan and they will select the best resolution plan. So whichever is significantly better, sir, that will be now submitted to the adjudicating authority, where the resolution plan selected under subsection 9 is considered for approval. Okay, the resolution plan selected for approval under subsection 10 may be approved by the committee of creditors for submission to adjudicating authority. Where resolution plan selected for approval is not approved, then people, the resolution professional shall file an application for termination of PPRP. We saw all this. Yes, I've just taken you through this. That's all, everything. Sir, what is impairment? Claim shall be considered as impaired where the resolution plan does not provide for the full payment of the confirmed claims as per the updated list of claims maintained by the resolution professional. So whatever I've written as list of claim, whatever you will get, you're not getting that much amount, you'll be considered as impairment. Approval of resolution plan is, people, adjudicating authority will have 30 days time. He may reject, people, pass an order accordingly, reject, terminate, declare PPRP cost shall be included in the liquidation cost. We saw that. Sir, appeal, sir. This we have not seen. Concentrate. So 54 L to M we did not see. Sir, now people, this is same which we had seen in 61.3, but yes, we'll again do it. According to section 61.3 of the code, an appeal against the order approving a resolution plan under section 31 may be filed on the following grounds. Sir, an authority has passed. We have already seen it there also. Same thing only. When I gave you the example of that Twin Technologies Videocon, same thing. Sir, the approved resolution plan is in contravention of the provisions of any law for the time being in force. You have Contravened Companies Act, SEBI. Sir, there has been a material irregularity in the exercise of the power by the resolution professional. Same dog. You try to compare. Both are same. Third one, the debt owed to the operational creditors of the corporator have not been provided for the resolution plan. People, we have missed out operational creditors. The insolvency resolution costs have not been provided in repayment in priority. People, the first cost should always be insolvency resolution cost that has been not given, sir, or any other criteria. You can go for an appeal with, where will you go for an appeal? Obviously, you will file it with NCLT. You will all obviously file it with NCLT, correct? Sir, termination of prepackaged insolvency resolution process. Now this, concentrate, people. Sir, now what is this, sir? At any given point of time, sir, the insolvency PPRP has started. Sir, now we are telling stop it. Don't continue. Termination means, people, we are telling you to stop. When will that happen, people? Now see. We'll see when it will it happen. First one, sir. Where the resolution professional files an application with AA under provision of 54K12. 54K12, what was it? We have written 54K12. Sir, none of the resolution plan was agreed. The resolution professional, sir, committee of creditor, none of the resolution plans they agreed. So resolution professional will file an application to adjudicating authority. Sir, please terminate this PPRP. That one. Clear? Okay. Sir, second one. Sir, under 54D3, the AA shall within 30 days of the date of such application by an order. Sir, what is 54D3? Go back. 54D3. Yes, people. Where no resolution plan is approved by committee of creditors, Within time referred above, the resolution professional shall, on the date after the expiry of such time, file an application with adjudicating authority for termination. People, what is this done? Sir, where there is no, this one agreed in 54K12 also we saw, if no plan is selected, you did not select from either of that plan. Okay. But people, imagine there is no plan at all. There is no resolution plan and 90 days is completed. Sir, 90 days we have completed. So people, 54D3, we have exceeded the time limit. 54K12, we have not agreed with the plan. That is what is the difference. See here. No plan is approved by committee of creditors within the time period. This is important. Yes, people, again same thing. File an application, resolution professional will file an application, sir, PPRP terminate. Got this? People understood that, that's all. The chart is crux. I'm just making you guys go through the left out points. I've made your life even more easier. I'll show you. See? What is this? People, difference between CARP and PPRP. Wherever there is a difference, I've given you the points. So is it there in the syllabus? It's not there in the syllabus. Just know. Just randomly go through. You will know, correct, there's a difference here, there's a difference here. Yeah? Huh? What done? Happy, huh? Study. Pass and show the result and then we'll see. Nonsense. Yes, people. So people, see resolution plan. Yes, sir, files an application with the adjudicating authority. Sir, when will the PPIRP be terminated? First one, people, when the resolution professional files an application. Resolution professional will file an application under two scenarios. 54K12, when resolution plan is not selected. That. 54D3, where you have exceeded the time, no plan approved. Yes, people. So we may terminate the PPIRP, provide for manner of continuation of proceedings initiated for avoidance of transactions. So whatever had happened, the avoidance of transactions rules, we will come to that. A fraudulent thing will come. We have not yet done. So where the resolution professional at any time after the prepackaged insolvency commencement date, sir, where the resolution professional any time after PPRP commencement date but before the approval of resolution plan under 54K4 or 12, 4 people base resolution plan, 12 people the given plan given whichever is best by resolution applicants, as the case may be, intimates the adjudicating authority of the decision of the committee of creditors approved by a vote of people 66% of the voting share to terminate the prepackaged insolvency resolution process. Sir, what is the third one? People, first one, people, RP decides. First one, we have exceeded time. Second one, people, we have not selected the plan. You write it in the book there only. Whatever you are seeing, you just write it there. You will have a fair idea. Okay, second one, people, COC has decided to terminate by 66% majority. And it has intimated resolution professional. So resolution professional is intimating to the adjudicating authority. Third one, people, where adjudicating authority passes an order of termination, the corporate debtor shall bear the PPRP costs, if any. Okay. Where the adjudicating authority has passed an order under section 54J2. 54J2, what is that? Takeover of management by resolution professional. Adjudicating authority has passed the order and the pre-packaged insolvency resolution process is required to be terminated. So people, adjudicating authority has passed that order and people, you guys have not done that. So people, PPIRP will be terminated. So people, and he may pass an order for liquidation in respect of corporate debtor and declare the PPIRP costs, if any, to be included in the liquidation cost. So people, this is when you are not complying with 54J2. What is this, people? Basically resolution professional to take over the management of corporate debtor. And this has not been complied. So sir, correct people, 3 grounds. One, resolution professional. You have not selected time barred people, COC only 66% approval. People, you have not appointed basically you have not passed over the management. That is your what, sir? 54J2. Okay. Almost done, people. Yes, we are left with only one more section. That's all. That is this 54O. What is this, people? See. Initiation of CIRP 54O. People, so 54O. People, what is 54O? Initiation of CIRP. People, know what is this? In short, I'll tell you. Sir, we have already started PPIRP. But our committee of creditors, people with 66% voting, they feel, sir, for us PPIRP is not sufficient. Please convert us to CIRP. Is this possible? This is what is given under 54. Now, whatever we are seeing, people. Oh, now people concentrate. Sir, is it possible? The answer is yes. This is possible. If PPRP has been started, but still it has not been terminated or it is still going on, basically, you can convert to CRP. How, sir? People, the committee of creditors will intimate to resolution professional. Resolution professional people will intimate to adjudicating authority. Adjudicating authority people will pass an order. Yes, sir. Now, when you are giving an order, people, resolution professional should also give his consent. Why, people? Now, because from the day adjudicating authority passes the order, people, that order will have the same effect as given under section 7 of CIRP. What is that, people? Sir, order for initiation of CIRP. Now, the same resolution professional shall be continued as an interim resolution professional. Now, whatever is there, people, everything will continue under CIRP. Provided, people, your default has to be 1 crore. That condition, though, you have to meet. Yes, just like that, you cannot come under CIRP. This is clear, all of you. Okay, sir. Sir, what if the resolution professional does not give his consent? Adjudicating authority will ask for IBBI's help. Sir, he is not giving the approval. Can you give me a new resolution professional? So he will become IRP. Is this clear, people? All of you. Sir, and one more thing, people. Whatever was the time period, it had elapsed here. The time period will be substituted here, people. Meaning what? Imagine you have consumed 30 days already. In your CIRP, you are maximum entitled for 180 days. So people, that will be deducted here. You have already killed. Now you have 150 days only. Is this clear, all of you? Pakka. That is what is given in O. Committee of creditors at any time after the pre-packaged insolvency commencement date, but before the approval of resolution plan. So they have not yet approved the resolution plan. By a vote of 66% may resolve to initiate CIRP in respect of the corporator if such corporator is eligible for CIRP process. So people, default 1 crore. Where resolution professional intimates AA, the committee of creditors, the adjudicating shall within 30 days of the date of such intimation pass an order to terminate the PPIRP and initiate CIRP, and it will appoint the resolution professional. If at all, people, he has not given his consent, we'll come to that. See, where the resolution professional fails to submit the written consent, then people, adjudicating authority will ask to the reference to the board to ask to give us a IRP. Yes, people. Whatever was the cost of PPIRP, people, that will be considered as a cost of CIRP. Everything will be added there. So now the adjudicating authority will pass an order. Such order shall be deemed to be an order of admission. So that is when, again, from that day, CIRP will commence. No other order will be given. CIRP shall commence on the date of such order. The proceedings initiated for avoidance of transaction, that preferential and all, will come back to that. For the purpose of section 43 and all, the insolvency commencement date shall mean pre-packaged insolvency commencement date. So we have to take from that day only. I told you, no, that 30 days will be counted. That is what is given here. In computing the relevant time period, whatever is PPIRP shall also be included. Clear up, people? All of you, this is 54O. So people, this is your PPIRP process. This is same now. Whatever is the provisions of chapter 3, 4, 5, that will apply to even this particular chapter also. Now say for example, wherever you had insolvency commencement date, here it means insolvency PPIRP date. Here you said RP or IRP. Here it means only RP. Same thing, people. I hope this is clear, all of you. Yes. Now try to see the differences, people. Now try to see. People, this is applicable to a corporator. Here, people, it has to be a MSME. Sir, priority, people, write down this one section, people. Section 11A. Section 11A. Yes, sir. People, sir, what is this 11A? People, just make a note of this one point, people. Sir, now what is this? Under 11A, people, there is one provision. What is this 11A, people? Sir, what if there are simultaneous applications filed? What do you mean by people? Sir, imagine we get an application under CIRP process as well as your PPRP process at the same time with adjudicating authority. Sir, now which application should be given preference by adjudicating authority is the question. So the law says, people, whenever you get an application under 7, 9, 10, 7, 9, 10 people basically filed by your financial creditors, operational creditors, corporators. So sir, imagine there are two situations that can happen, or 54C. 54C people, your PPRP process. Sir, application under section 54C is pending. That is, sir, first 54C was already filed with. Imagine, people, on 1st Jan 2022, someone has already filed an application under 54C. On 3rd Jan 22, someone is filing an application under CIRP. The law says, people, whatever is filed first, that is 54C is filed, sir. Sir, if 54C is filed first, people, then the priority or preference will be given to 54C only. That is for PPIRP. Sir, imagine, let us take the other scenario. People, on 1st January 2022, sir, CIRP was filed. Sir, imagine, people, on 10th January 2022, PPIRP is filed. Now, what does the law say? Listen carefully. Application is filed under 7, 9, 10. That is first filed. Before application 54C. So, first that is filed. Before filing 54C only, this is filed. Okay. Application under 54C. Sir, you are saying that first 7, 9, 10 application is filed. After that, you are filing application under 54C. That is, first CIRP is filed. Next, you are filing PPIRP. Correct. Now the question is, how many days after you are filing the PPIRP application? Sir, on 1st January, my CIRP application is already there with adjudicating authority. If at all you are filing it, people, before 14 days, within 14 days of filing the application of CIRP, sir, it is filed on 1st January. If you file it within 15th January, people, the law says the preference will be given to PPIRP process, not to CIRP. Sir, if at all it is filed on 1st Jan until 15 Jan, that is 14 days, people, it will be, because first day we will exclude. So people, until 15th Jan, you will give preference to PPIRP process. Remember that this can be important. Are you guys clear with this? Okay, sir. Imagine, people, if your application is filed on 17th Jan 2022, which one? PPIRP. Yes, people, the law says if it is filed after 14 days of whatever is filed of CIRP, then CIRP only will be given first preference. This is what is given in 11A. Just make a note of it, that is sufficient. Clear, people? Important. Okay, now let us go back to our differences. So that is what I have given here. So people, PPRP gets priority. Minimum default 1 crore, 10 lakh. People, there is no preliminary work required. Pre-packaged work is not there in CIRP. People, here there are so many. What is that? First one, you need to pass special resolution, approval by financial creditors, name of resolution professional, base resolution plan, people, and a report by resolution professional. He is filing it. No, so all that is required. 54B. Following persons can initiate CIRP: important financial creditor, operational creditor, corporator. Here, people, corporate applicant. We saw who is a corporate applicant. Time limit, people, 180 plus you have an extension of 90 days, correct? People, here only 120, absolutely no extension. Same moratorium and all, same, people, no difference at all. Moratorium, same rules and all, everything is same. So here, people, you will first appoint IRP, then he will become RP. People, here directly we appoint RP. People, management of corporator is with the CD, I mean, is with the insolvency resolution professional or RP. Here, people, it is with them until the default happens. Claims of proof to be submitted to IRP here. Claims of proofs to be submitted to IRP. Here, people will submit it to RP if at all there is any revision. Resolution professional appointed in first meeting of creditors. Here, before only is appointed. Adjudicating authority appoints. Information memorandum. People preliminary prepared by RP here. No provision for base resolution. There is a base resolution plan here. Invitation to resolution applicants as per criteria. People, if BRP fails is when we will ask for RPs. If not, people, that provision itself does not come. Correct, people? So just made some differences, people. If you find many more also, you can add also. Clear? Okay. So people, that is your PPIRP process. I hope it was simple. Go through the chart and come here. Most of the process is simplified. Clear? Pakka? Awesome. Thank you, people.